Thank everybody for showing up for our work session with Pamela today to review open meeting law. I see we have some representatives from the EDA here as well, so it'll be nice for the council and the EDA and hopefully some of the other subcommittees take a look at this. It's going to be on YouTube on our fabulous famous new YouTube channel as well. So at this point, we'll just welcome Pamela here and have a conversation about open meeting law.
So who's from the EDA? What's your name?
Kathy Longer now.
Kathy?
I'm sheriff right now.
Yeah. Nice to meet you. Nice to meet you. Who else is here? Anybody from our committee or commission? No? Just Kathy. Well, I think I must be scary enough because 2 council members didn't show up either.
Right.
So I was asked to overview the open meeting law, and I will tell you from the get-go that there's many things about the open meeting law which doesn't make sense and seems silly, but the legislature and a special agency, which is called the Data Practices Office, interpret the statutes that make up the open meeting law very literally. So just so you know, we'll touch on some of those. This is a presentation that I do for a lot of different agencies across the state. So I might skip through some of it because it might not be as relevant. Plus, it's generally an hour. I'm guessing you don't want me to take an hour.
I'd appreciate it.
If I could take an hour?
No, if you were efficient enough to condense it, yes.
The open meeting law is a set of statutes found in 13D, if you care to go find it when you Google Minnesota statutes, that basically protects the public. That's the whole purpose of the open meeting law, is to make sure that government's transparent. So I always say for my elected official or my appointed officials who are subject to the open meeting law, which by the way is all appointed committees. If the rule is if it's a standing committee of the council, then it's going to be subject to the open meeting law. And then the statutes very specifically name other things like the Fire Relief Association, EDA, Planning Commission. Those are all very specifically called out. Though the committees that the open meeting law generally doesn't apply to is if somebody comes and wants a skate park and the council gives direction to a group of citizens to just gather some generic information to come back to council, that type of committee is not going to be subject to the open meeting law. But the easiest way to think about the open meeting laws is to step into the shoes of the public. And so what it is intended to do is to prohibit secret meetings taken without notice or the right for the public to be present. So those are the 2 biggest things of the open meeting law. You think we could just shut down my computer and be done because it would be simple. But it gets hard when actual operations and business starts. So that's kind of what we'll focus on. And so just quickly, the council had a holiday get together last Friday night, right? Subject to the open meeting law or not?
No, as long as we weren't talking about business.
Right. So a quorum or more of the decision makers were present together somewhere. So that is the first thing to think about, because the public has a right to know and be present to listen to a group of decision makers who are enough that can make a decision. So a quorum or more of decision makers are all together and they're talking about official city business. And so that's when the public has notice opportunity to be present as well. But just to make sure that nobody gets upset and says there was a bunch of decision makers all together and we didn't know about it, what did your amazing clerk do?
Post a notice of a possible quorum.
She posted notice of a possible, there's going to be a quorum or more of decision makers at this location. No official business is going to be discussed. So it's an easy way to work within it. It doesn't mean that everything has to shut down because there's a statute that says you can't all get together. So that's just kind of a good way to think about it. So here's some of those ones that we talked about, but HRA, EDA, those are all called out in statute. And so Again, it's advance notice of the meetings, and then you hold the meetings open for the public, for them to be present and monitor. So notice gets to be different. So this tonight is a regular council meeting. So all that has to happen, or your regularly planned EDA meetings, is that on file in the office is a schedule for the upcoming year of the meetings. That's enough notice for regular meetings. If there's some kind of change to that meeting, or if there's a new meeting called, that's a special meeting, then all of a sudden that's a special meeting and it's 3 days notice. So you count the day, you don't count the day of notice, but you can count the day of meeting.
You count weekends?
So, so those are the requirements for notice. So where it gets tricky when I talk about the tricky things, let's say somebody joins remotely. Let's say Landon wants to join while he's in Mexico, which we'd all think we're crazy for doing.
I won't be. I will not be,
Hypothetical.
I will not be of. I will not be able to make decisions at that time.
Okay. Thank you for being responsible. So let's say it's a regular meeting, you would think you wouldn't have to notice it because it's on schedule in the office. But the fact of him joining from a different location, all of a sudden makes it a special meeting under the statute. So then notice has to be posted. Now, it doesn't have to be published, doesn't have to be published in the newspaper. The statute literally says on the community bulletin board, and if there isn't a community bulletin board, on the door of the meeting site. So that's the only notice requirement. So there have been cities where they're up to date with their technology. They'll put it on their website, but they won't put it on their bulletin board, and they have been found in violation of the open meeting law. Okay, again, when I say it's kind of can be silly in its enforcement, that is one of the instances. So the courts and the data practices office are very literal interpreting it. Now, good best practice to put it on your website? Absolutely. But if somebody calls the city out for not having it on the community bulletin board or the door, then that would be a violation. You want to ask a question, Mayor?
Yeah, so do encounter some instances where people do actually want to participate and vote in situations like that. What are the minimum requirements for that?
So there's actual provisions on that. So it's, as long as you have interactive technology, which we do, because we're actually using it, and everybody can see and hear the person who's gone. So everybody in the room can see and hear Landon. Landon can see and hear everybody else. Then he can join, and it's a meeting as long as it's been noticed, because it would need that 3-day notice because he's joining remotely. And everything needs to be done by a roll call vote then, which was new in the statutory provisions. So if somebody joins remotely, everything has to be done by a roll call vote. And he is supposed to post notice at the location he's at, and he's supposed to be in a public place.
Okay.
Now, wink, wink, does it happen where people are not in public places? Probably, but that's what the actual statute says, is that he has to be in a publicly accessible place. So a library, the lobby of the hotel, if anybody's invited to the hotel, that kind of thing. And he's supposed to have a piece of paper posted that said, I'm in the city of Olivia council meeting.
Okay.
So those are the requirements to join remotely. Additionally, especially with COVID when it happened, there is an exception when there's an emergency like that. If there's been an emergency declared, then there can be a determination under that emergency provision that everybody can join in remotely, as long as there is one person here at the location. When there's not an emergency, which just Landon joining from Mexico would not be the emergency type situation, there has to be one elected official here, at least one elected official at the location site. And the public has to have the right to be present.
Thank you.
What about if I'm ill?
So the legislature made a change to the statute before. Too bad. That was just a mismeeting for you. You could call in and listen, but you couldn't participate in voting or establish quorum. When COVID happened, they allowed it for a certain amount of time after the emergency was lifted. You could call in from your private location. Now, in the most recent session, they said, okay, this is, remote technology is so great now. So now, as long as you have a health condition whether it's, you know, temporary or not, where a doctor would say, yeah, you shouldn't be out in public, or you have a family member who has that health condition. And then you can call in from a private location without posting it for up to 3 times every year. So you can't do it all the time. You can do it up to 3 times every year. So that is a change. The other exception is if you're in the military and you're not able to be in a public location because you're in a secured facility or a secured base, you also get to be able to be there for 3 times in a year. So you can join 3 different meetings without having to be in a public location if you're in the military. So those are the exceptions.
Pamela, can I ask a question? Early on, you were talking about a quorum.
Mhm.
So the EDA has a subcommittee, which is not a quorum, but I'm given to understand that we need to post those meetings
Well, so what's the purpose of the subcommittee?
to discuss business that we will bring forward to the board.
Yeah, because so that's that one of those layered. It's a standing committee of a board that is subject to the open meeting law, and it's making official business recommendations to the board, which oftentimes is taken. So that we usually default to making the recommendation that that committee is, as if there's a quorum or more of the appointed decision makers, then to have that be noticed and have public be able to be present. Now, if there was a mix so that there was more staff than decision makers, then that wouldn't trigger the open meeting law. It's the whole open meeting law is all about the decision makers and public being able to be there to hear the decision makers and learn what they're thinking.
So they could meet if it was one less than the quorum of the EDA.
So, but what if they're the quorum of the subcommittee? Like the subcommittee is 3 members of that committee. Is that a quorum of that subcommittee?
Well, so if the quorum, then you'd have to do an analysis of the subcommittee and whether that itself is a decision-making entity. And so if it's determined that it's a standing subcommittee that really is making decisions that are just always accepted, then again, you'd have an analysis of how many decision makers are on that. Staff is never considered. So it's either the elected or appointed members of the ultimate body. Does that make sense?
So you're putting into different categories, decision-making and also recommendation-making then.
So I'm talking about the actual individuals who are sitting on the committee. So if they are either the elected, you're all elected except for Elizabeth, or in committees, they're appointed to be a decision maker, but they establish quorum. Anybody who's the quorum, who establishes quorum of the main overarching board for a subcommittee would be the ones who would be considered making up a
Decision
quorum.
makers, okay.
Yeah, making up a quorum. Does that make sense?
Yes.
Okay. Okay, so what's a meeting? That also gets very confusing. Obviously, this is the easy one. This is a meeting. What about an email that goes to the council with an updated agenda item? And one of the council members responds back and says, tell me again how much that play structure bid was. And another council member responds and says, well, it was way too much and I think we should have gone with the other person. Is that a meeting?
Yes.
Yeah. Because all of a sudden you have a discussion of official city business, even though it's not in person, of the decision makers, of a quorum or more of decision makers, and the public hasn't gotten notice and they aren't privy to that email to watch it all going on. So it applies to emailing, it applies to texting, it applies to if on social media, there's one post where everybody's discussing, not just posting out, but just actually having a discussion, sorry. So keep that in mind when you're interacting with each other as decision makers. And the other thing is, and this is really hard because many of us are used to being in private practice or private business, and you're used to maybe getting a feel how one thing's going to go or another, kind of pulling people. If one person, Matt, if you talk to the mayor talks about the same thing to Landon, all of a sudden, even though it didn't happen at the same time, that's a meeting that the public hasn't gotten notice of and wasn't able to be present. So whether that happens verbally, whether it's by the telephone, texting, emailing, any of those, it doesn't matter the way that it happens. If you're talking about the same item, official business, then that's gonna be considered a meeting. So that daisy chain
Yep.
is what gets people in trouble. So,
Anything, I guess.
right. Um. So this is this is just an example of it. You know, we've been talking a lot about cannabis and THC. Chair texts neighbor George, who's on the planning commission, who texts back, and then that planning commission member texts another planning commission member. If there was 5, then that would be a violation. So, what about this? Mayor found an article about THC and the impacts on public safety and emails the article out to the council for council to have before the meeting. Is that a violation?
Yes.
Not yet.
Oh.
So
There's no
information
discussion.
out is fine. That's why we always say BCC, because nobody can reply all. If somebody replies all to that, then that's a violation.
But it's just information sharing.
It's
No
just
discussion.
information sharing, no discussion is fine. So, but use BCC, because then you can't get into trouble by someone forgetting and then emailing back everybody, and then all of a sudden, that's a violation. Now, admittedly, unless it's the media who is always, who's watching you at all times. Is anybody gonna know, do the skies open up and, you know, the lightning strikes that you had an open meeting law violation? No, I mean, somebody has to know about it and report it, but it's good to get into best practices and habits because it's really easy to mess up unintentionally. So that's serial meetings. Am I going backwards? Yep. So what about a staff person? If the staff person emails out all members, and is that a violation of the open meeting law? So that's a good best practice is to, if you're worried about sending information to everybody and you don't want to even set up the chance or likelihood that somebody replies all, just send it to staff. Staff can send it out to everybody. Again, you'll notice that Elizabeth does BCC for the same reason, and then there's no issues with the open meeting law. Open meeting law does not apply to staff members. So you can't use her, however, to make a decision.
Even user to make a decision.
So there was a city that had to get an MPCA letter in, and the staff member sent it to each council member. And they made their edits, sent it back, they'd send it on to everybody, review, send it back. So they did that serial
Yeah.
meeting, but through the staff person, then the staff person sent it to the MPCA. And that was a violation. Somebody in the public found out about it, brought a legal action, and there was a violation of the open meeting law.
It's $300.
It is $300 per violation, and but there are some city, and it's individual, city doesn't pay for it. The defense of an action actually brought in court, you know, with attorney's fees and costs, because those aren't attorneys, right? They generally run around $13,000, but with our league insurance, you have open meeting law coverage. So they'll defend it, they'll cover the cost of defense under your insurance, but the individual penalties are on you. Keep in mind, there's some individual council members who in different situations, they got sued. It was about a development project, meeting with developers. And their fines were like $6,000 to $7,000 because of the number of times they met with the developer. So it can add up. All right. So we talked about this again, like that MPCA situation for that one city. I would have just told my city as a city attorney, if there's a deadline and it's going to impact your public health or your budget or anything, then call an emergency meeting. You know, that would be your generally emergency meetings are, those situations where you can't gather. There's a health pandemic. We just went through COVID. Maybe there's flooding or something that you can't gather. You need to make decisions. But there can also be grounds for emergencies when there's a deadline that is coming up and you just don't have time to meet under the open meeting law. So,
Call snap emergency meeting if you need to.
and you have to, you can, yes, but you have to give reasonable notice as best you can. And you have to, the staff needs to individually reach out to the council or the decision makers to make sure that they know about it. If it gets challenged though, it's really scrutinized, like, was it really an emergency? And if public finds out that you're calling emergency meetings, then they do sometimes get pretty, retrospective about those, so. All right, so, we've talked about this, but what do you think? A closed meeting a half hour before the regular meeting, since it'd be a good time to make, because everybody's gonna be here. And it was about performance evaluation, so they just held it a half hour before. Any issues with that?
Depends.
Okay, why?
Did they provide, notice?
So if they have provided notice, then it's fine. 3 days notice because that would have been a special meeting. If they hadn't provided notice and they just thought, oh, everybody will be here, that's not fine. So, all right. Oh, this is a good one, especially in a smaller community. Let's say that the planning commission is talking about a property that is a problem property and they want to walk over and see it. And so they put a note on the door, you know, they're in the meeting, let's walk over and see it, put a note on the door. This actually happened. Issue?
I say yes because it's on the slide.
So the courts considered this to be a change of location for the meeting, which makes it a special meeting, which means they would have had to give 3 days notice. So,
I ran into this when we were trying to go look at the Renville County
Oh, yeah.
or the Renville City stuff.
so if you have public, this is about, this actually, all of these happen, so, there was a city that had citizens protesting, approached, the dais with signs, interrupted council meetings. They tried to work their way through. So mayor, they couldn't do that. Mayor took a recess. And so then they went into an alternative conference room, finished their business and came back to hear the public. Issues?
Yeah.
Change of location and not accessible to the public, so. So, those are all, that part that I skipped through is what we talked about remote meetings. So. How about this? Suburban city holds annual goal setting session at a hotel in another suburban city. Thoughts?
Ad optics?
Ad optics? So notice was provided to this, because it would have been a special meeting, so notice was provided. And it was in a hotel that was open to the public. And it was, yeah, you'd think so, right? Nope, they said for the public in that city, you're moving it outside of their jurisdiction, which makes it difficult for them and not as accessible for the public. Now, they've made exceptions for this in different townships. But if you're gonna do if you're gonna meet somewhere else, do your best to have it be within city limits. So what about this? Because this is something that's been coming up lately. So the city has an emergency declaration. There's lingering COVID. So they decide to broadcast the meetings. So the commission was present in the room, but public was limited to joining online and not being able to be in the room as well because of health reasons.
It's a violation.
Because the public has to be able to be present. Now, the flip side of that with all of our technology is that many cities are allowing public to join remotely. That's not required. That's just, some cities would think that of that as a public service or a good best practice, but I still have cities who, since COVID's been done, don't stream their meetings. So there has been some cities lately where there has been public cuts. So that some cities will, in addition to that, have their comment period also open through the online feature. And so there has been some issues lately in different cities of people calling in and talking about federal issues.
Oh.
And some inappropriate racist type and discriminatory type comments as well. And so the question is, can you then shut them off? As far as their comment period. So that's why I really encourage the city, and Elizabeth and I are going to be talking about this later this week and possibly bringing it to you if it's of interest or not. To have rules, just rules around your public comment, and especially if you have some online. So that you can create a forum that is ability to be somewhat controlled, because the open meeting law doesn't require public comment to happen. But if the council allows public comment, then you have First Amendment concerns because you've opened up the forum to be able to have some discussion. So then you have to worry about First Amendment rights. So.
And at what point do we arrest them legally when
Well,
they take
so-
away that right? I mean,
That's why we want to have good policies in place. There is an obstruction of justice statute and disorderly conduct statute, as you well know. That got over the portion, there was one portion of it that allowed removal from public meetings that got overturned, I don't know, 6 years ago? Were you aware of that?
no,
So Little Falls has a resident who took that to the Supreme Court and was successful in getting that portion of our state statute overturned, that if there is not any other crime being engaged in, like assault or threats or something like that, then just disrupting that public meeting is no longer considered disorderly conduct because of the First Amendment. So that's why it's really good to have a conversation about what do you want your public comment policy to look like, so that if anything happened, you would have policy in place to say, look at, we have this policy, it's communicated to everybody. The purpose of this public comment time is for public to share input and information about city business, so that, you know, you can then have a justification for shutting off anybody who's talking about federal politics. Have a time limit that there's Crow Wing County. I don't know if anybody's seen the videos that come out of Crow Wing County. They have one resident who dresses like a clown and spends the whole entire 3 minutes honking a horn. And they just let him do it. He has his 3 minutes and then he sits down. And so so they have that. So it's really important that they have that time limit, because they happen to have a resident who comes and just honks the horn. And so there's different things that you can do. So you're gonna be looking all these up later, right? Just something to think about. All right, closed meetings. We've had closed meetings. You can't close a meeting for any reason. So there's very specific reasons, as the mayor well knows, because I always make him read all the language of the sections of why we're closing the meeting, because that's what's required. So the member of the elected body has to be the one actually closing the meeting. I wouldn't be able to close the meeting, and there's only specific reasons to close those meetings. And so if there is closing for performance evaluations or allegations of misconduct under council's authority, of someone under council's authority, those individuals about whom that review is, or those allegations, can choose to have it open. And then the council must have it open. So
What are the three? Is property,
here, right here. So must close for the allegations of misconduct under council's authority, but for the portion of where the individual wants it open, but the rest of the meeting for the council to have a conversation can be closed. And then you must close for certain non-public data, which is very specific. It's really to protect like undercover police officers, or maybe some health-related data, that kind of stuff about a specific individual. It's not just because the city might get sued and they wanna, or maybe the city's thinking about, walking away from a contract. And they don't want to have that conversation in public, and they say, oh, Pam, come, you'll be the attorney, we can close it for attorney-client. Nope. Because you could really, honestly, the courts have said, you could say that about anything. You could say, literally say that about any decision you make. You know, somebody might get upset, we might get sued about it. So it has to be very specific for not public data, and then for attorney-client privilege on the other side, it's limited to threatened or pending litigation. So, and the court weighs and balances that. So you may close for, but everybody pretty much does on this right-hand side. Labor negotiations, employee performance review unless the employee wants it open, purchase or sale of property, so that you can talk about that appraisal data, that kind of stuff, and then security data. And you don't want to get a security system for your city hall and then have to have that discussion of how it works in public. So the process to close is a member of the body closes and you cite to the statute. So pre and post meeting discussions, it's just, you know, the one thing we didn't talk about, just like the social event, those are amazing to have good relationship bonding. But when you're out and about, sometimes public perception is worse than whether you're actually talking about official city business. I had a city where when I worked at the league, I had to go work with them because the community was very upset because 3 of the individuals on council were friends with each other and had been for years. It was a smaller community. One of them had a store. And so every Tuesday morning, the other 2 would go out for coffee. And the amount of time and attention the public paid to when the trucks were outside the storefront was really unbelievable. And then what happens is then they all go over to City Hall and talk about how those 3 are, you know, at the store again, talking about city business. So just be careful. Sometimes public perception causes more of a hassle than just, you know, if you're not talking about city business, then it's not an issue. But people like to talk. So keep that in mind. And then this one happened, and it actually led to a lawsuit where one of the council members sued his colleagues for what he said was violating the open meeting law, and it went to district court. So meeting was adjourned, everybody was packing up. And it wasn't this particular situation, but what happened was they had a presentation and the screen was down. And so 3 of them were just packing up the stuff, just chatting about family or whatever. But the other council member assumed, because they were making hand gestures and the screen was down, that they were continuing the discussion about whatever was presented, and actually sued the other members of council in district court for open meeting law violation. And what the judge said was, well, there's no evidence that they were actually talking about it, official city business still, so there isn't a finding of open meeting law violation. But if you had evidence, then yeah, that would have been a violation. So we just got to be careful when meetings close, after the meeting's adjourned, what we're talking about.
Avoid lawsuits, even if they don't bear any fruit for anybody.
I've got
so-
one more question.
Yeah.
So bear fruit for the lawyers.
Okay, so back to this subcommittee
Yeah.
situation.
Yep.
So we're gonna post that it's an open meeting.
Mhm.
But if we're discussing sale of property or something like that, can the subcommittee close the meeting?
So for purchase, or sale of property,
To
appraisal
discuss making
value,
recommendations to the full board.
yeah, appraisal, purchase price, that kind of stuff.
So
you
a
can
subcommittee
close for.
can also close the meeting.
Yep. So a member of the actual body has to close it, of the
Sure.
subcommittee body, and you just cite the statute and why. So the public who's there, who's gonna have to leave because it's gonna be a closed portion of it, need to know why you're closing it.
Okay.
There are exceptions, social gatherings we talked about. The other one is league events. That's specifically called out. You can be at a league event together. And team building, they don't consider that a meeting. So if we had some kind of team building, talking about your relationship as opposed to official city business, that's exempted out as not a meeting. So, social media, we touched on a little bit, and just the state statute allows elected officials or appointed officials in their role as a decision maker to use social media. But once you start discussing business on one post together or in one area together, then that could be a violation. So the $300 fine, here's the personal liability. There can be a forfeiture of office, but it's actually left up to the council. So the council votes. If there are 3 or more separate intentional violations, the judge can make that finding and then let the council know, and then the council makes, has a discussion and makes a decision of whether the person who has made those, who is engaged in those violations should be removed from council or not. So. And the mandatory attorney's fees is sometimes, like I said, nobody, you know, does the skies open and does lightning strike you when there's open meeting law violations? No. But the fact that anytime there's a hot issue or you're having closed meetings or people are upset about something, they're going to be constantly vigilantly watching. And the statute allows for attorney's fees regardless of whether there's success or not. So there's attorneys who are more than willing to take these cases because they're guaranteed to get paid. So just keep that in mind. Okay, so 3 days notice for regular meetings, true or false? Right, that's just for special meetings. Regular meetings are kept on file. Can you tour the wastewater treatment facility?
Yes. Posted as an alternate location.
And if your facility, which I imagine wouldn't be, is open to the public, because public has to be able to come with you. So any locked facility, you better go in groups of less than a quorum.
Oh.
It is.
Just let me see what happens.
Do you have to follow parliamentary process under open meeting law? Does it require it? Correct. Just a good idea to keep things moving. Is the action that's taken when there's an open meeting law violation reversed?
So, huh?
You'd think so. Nope, it stands. You just get fined. But the actual decision stands.
Worth $300, yeah.
All right, last one. Does the open meeting law give the public the right to speak at an open meeting?
No.
No. It just allows them to have access and be present and listen. But as I said, it's the only time that public has all of you together because of the open meeting law. So I personally think it's a good practice to have public be able to have some time to speak, but I am a true believer of having some parameters around it. So that's it. How'd I do? Less than an hour?
Yeah.
Yeah, you did great. Thank you.
You're welcome.
Very beneficial.
Okay. Not calling you out. You're just- All right.
We'll
Thank